Good morning, everyone. Welcome to everyone here in Carson City, as well as those in Las Vegas, and of course, anyone watching online through Nellis or our YouTube station. With that, Committee Secretary, please take the roll.
Assembly members Cole. Here. Dahlia. Here. Gonzalez. Here. Gray. Here. Hanson. Here. Hardy. Here. LaRue Hatch. Here. Marzola.
Present.
Moore.
Here.
Nadeem.
Present.
Orenlicker.
Here.
Roth.
Here.
Urich.
Here.
Chair Miller.
Here. And just a few reminders before we get started. Just want to remind everyone to turn their electronics down. Also that we will have public comment at the end of today's meeting. Anyone wishing to make public comment or to testify on a bill by using the telephone may do so by calling the number 1-888-475-4499, and then the meeting ID for today, which is also identified on the agenda that you can find on Nellis, is 854-7652-8408. Again, I ask that anyone speaking today to make public comment or testify on a bill, that you keep your comments to 2 minutes. Anyone presenting a bill, that you keep your presentation to about 15 minutes. Of course, anyone speaking, we ask that you state your name, and the first time that you state your name, that you make sure that you spell it so we have it correct for the record. With that, we do have 3 bills on the agenda, but we are going to start. Before we get into our bills, we have 3 BDR introductions. So again, members, just a reminder that this is just a vote for the BDR introduction. It's just a vote for it to be turned into a bill, not a vote of your support or position on the bill. And so with that, the first BDR is BDR 14873. It revises provisions relating to criminal convictions of certain victims. Members, are there any questions? All right, with that, I will take a motion. I have a motion by Vice Chair Marzola. Is there a second? Second by Assembly Member Gonzalez. Members, any additional comments? All right, with that, I'll take a vote. All those in favor, please say aye.
Aye.
Anyone opposed? All right, the motion carries. Thank you. The next BDR is BDR 31141. This revises provisions relating to civil actions. Members, any questions? I will take a motion.
So moved.
I have a motion from Assembly Member Gonzalez. Do I have a second?
Second.
I have a second from Assembly Member Delia. Members, any additional questions or comments? Not seeing any. All those in favor?
Aye.
Anyone opposed? And the motion carries. Next BDR is BDR 0870. Any questions? Oh, yeah, probably what it's about. Okay, so this one revises provisions related to courts. And with that, are there any questions? Okay, I will entertain a motion.
So moved.
I have a motion from Vice Chair Marzola and a second from Ms. O'Krant? No. A second from Vice Chair Gonzalez. Any additional questions or comments? Not seeing any. All those in favor?
Aye.
Anyone opposed? All right, and the motion passes. Thank you, members. With that, I will be taking the bills out of order today. Which one's yours? Okay, so we will be starting with Assembly Bill 344, which revises provisions relating to the judiciary. With that, I will give the Vice Chair a few moments to get settled, and whenever you are ready, please proceed.
Good morning, Chair Miller and members of the committee. I'm Elaine Marzola, representing Assembly District 21 in Clark County. It is my pleasure to introduce Assembly Bill 344, which aims to modernize and improve various aspects of our judicial process, with a particular focus on child welfare proceedings and the appointment of attorneys in certain cases. Today, I'm joined by Kelly Brandon, Supervising Deputy District Attorney for the Carson City District Attorney's Office and the Chair of the Court Improvement Program Legislative Subcommittee, who will provide an in-depth overview of the bill and the amendment. Hopefully, everyone in the committee has the amendment as well. So with your permission, Chair, I would like to turn it over to Mrs. Brandon.
Thank you. Kelly Brandon, for the record, Brandon. I do work at the Carson City District Attorney's Office as the supervising district attorney over our juvenile division. It oversees our child welfare cases, which is why I'm here today. I serve as the subcommittee chair for the legislative subcommittee for the Court-Wide Improvement Project. That program encompasses every jurisdiction in the state of Nevada. It includes stakeholders that represent children, parents, the agency, the child welfare agencies, as well as members of our judicial body from across the state. The purpose of this bill is to help improve our process for juveniles and their families and ensure that our process is fair, and while also making sure that we provide appropriate representation. The vast majority of the sections before the committee address a change of a request to move the term from master to judicial officer. Originally, this came before the committee last year with some questions about an appropriate terminology to be used. There was some debate last year about whether or not we should use the term magistrate. That issue's been vetted through stakeholders outside of child welfare to make sure that it's clear, and it came at the request of multiple members of our judicial body who had received comments from children asking them if the term master had anything to do with slaves, and they didn't think that that was appropriate. There are other states who have also adopted similar provisions. The state of Maryland made the change back in 2018 to get rid of their term as master, and while I think the intent behind the phrasing initially was to ensure that it made it sound like they were somebody who understood the content specifically, that's not the way children interpret it. It's children who are in our courtrooms and who are hearing our proceedings, and so they seek to understand that and have a term that helps them understand and feel like they have access to that regardless of their race. The other areas address funding for attorneys, and that was brought forward by rural jurisdictions in the state who are struggling to get attorneys to represent parents in 432B child welfare matters. And that was partially caused by a change in payment for attorneys in criminal defense cases. And while those changes took place, the statute with child welfare lingered behind. And so attorneys were telling local jurisdictions, why would I take a child welfare case that's more complicated, that has more meetings, that has more things that we have to do for less pay, and I need to pay my bills and be able to take care of my family. And so we have updated those provisions to essentially ask that the jurisdictions fund those positions at the rate for regular child welfare cases, for our 432B cases, as we refer to them, at the rate of a misdemeanor criminal attorney, and in termination of parental rights proceedings at the rate of a felony attorney. That's because in termination of parental rights proceedings, the court has said that it's akin to the civil death penalty, and we think it's important that representation be provided that is high level and that the people are appropriately paid. The other part of those provisions is to ensure that those folks are paid for things outside of courtroom proceedings, because there are some jurisdictions who take the position that the current statute doesn't allow those attorneys to be paid if they participate in child and family team meetings, in mediations, and in things outside of the courtroom. In child welfare cases, the majority of the work is actually completed by attorneys not in a courtroom, but by in those other meetings with child welfare agencies and with other stakeholders to ensure that these cases are handled correctly. And so that was the request that went forward. The last piece is, I think, probably the most complicated, which is our transfer of proceedings inside the state of Nevada. If any of you are familiar with child custody proceedings, you know that when we transfer cases in between states, there are significant statutory provisions that are adopted across the country to allow for that. Section 27 allows for a court to move a proceeding between jurisdictions inside the state. It's an important function because in child welfare matters, multiple jurisdictions often have the ability to have a child in their custody. Provisions for children state that a child can be taken in protective custody if they're found in a jurisdiction, if they live there, or if they're domiciled there. We want to make sure that cases are not necessarily kept where the child is found, but where the family resides, so the child can get services, remain in their school, remain with placements that they're familiar with and in a community they're familiar with, and that's helped by having that proceeding take place. However, the jurisdiction that does the removal should also be responsible for adjudicating that case because they have the witnesses and the information to be able to adjudicate the case and make the decisions properly. If you look at the amendments that have been proposed, the request would just be to add a couple of things in that particular section, one of which would be to say that at a joint hearing that any person who had to be noticed also has to be heard. That's just to make sure that it's clear. While we expect that generally if you have a hearing and you notice parties that they have the ability to speak, we want to make sure that that's clear to every jurisdiction. And then additionally, at the request of some members of our committee, to add in a piece that says that any child receiving services, that the ability for that child to receive those services in the receiving jurisdiction would also be considered by the court to make sure that we're not missing that piece when we're assessing whether or not a case should transfer. The other amendments for Section 30 are largely just to make sure that things are clear for how this process works. And so to provide some context in how courts appoint attorneys, most jurisdictions in the state appoint attorneys before a 72-hour hearing. However, not all of them do. That's our protective custody hearing. And so not all of them have the ability to do so, quite frankly. And so the first section of that, of Section 30, so subsection 1, is about that first hearing. And so not all jurisdictions are in a position to be able to provide an attorney at that proceeding. And so the request would be that then they have that attorney for that hearing. Originally, the way that was written is it includes all of the types of hearings that come after a petition has been filed. Just because a child's brought into protective custody doesn't mean that a child's need of protection is necessarily going to be filed. So provisions for 432B 410 through 490 should attach following a petition being filed. When we made contact with our jurisdictions across the state, all of them indicated that they did consistently appoint attorneys where parents were indigent once a petition had been filed. And so that was the language that changed in that section. And then that would change the 410 to 490 because all of those proceedings follow after that. And then the courts had requested that there be a specific provision that allowed an attorney to represent a parent who isn't alleged to have committed something that caused a child to be in need of protection, but is nonetheless a party to the proceeding. Oftentimes, it's a non-offending parent who resides out of state, and there are times where it may be appropriate to appoint that person an attorney if there are legal issues or concerns that need to be addressed. And I'm happy to take any questions from anyone. Thank you.
Thank you so much. And I would first like to say that I really appreciate your consideration and sensitivity around the word, taking the word out, of master out, especially when children have voiced that question or that concern. So I really appreciate that. Thank you. With that, members, questions? We'll just give folks a moment to type in. We have a question from Assemblymember Cole.
Good morning. Thank you for this. This is, I think, a pretty interesting bill. So my question is, well, it's on page 24, so section 30, sub 4C, where we're talking about a change, I think, in attorneys to be appointed. C says requesting new counsel without valid justification, and I'm just curious as to who would be the determiner of whether it was valid, because it might be valid in the person's mind, but not reasonable.
So that request was made, Kelly Brandon, I apologize. That request was actually made at the request of parents' attorneys who represent these folks, because one of the challenges that we've had is depending on the mental state of one of their clients, they can often request things that don't, they're not a legal justification for a basis for somebody not being able to represent them. So oftentimes we receive requests to withdraw as counsel based off of a conflict or an attorney saying, I can't represent this person because we're not meeting eye to eye. We can't communicate anymore because of our positions. They want me to engage in unethical conduct. All of those things are valid reasons. The court would ultimately make that determination. And so they would be the people who make that determination based on their information they receive from that person's attorney, as well as from the parent themselves or from that party. It's, to be honest, there are often times we have parents who go through multiple attorneys, and it becomes to a point where jurisdictions don't have any more attorneys. I had a case that I was on where I had 7 different parents' attorneys over the course of 7 or 8 months because the parent kept threatening to harm their attorney. And so it became an issue of attorneys having to get protective orders against their client and then having to withdraw. And so I think those provisions are there to protect if there's something that goes above and beyond typical things that happen in a courtroom, which is there are times there are personality conflicts, there are times there are disagreements. Those are completely valid reasons to have a new attorney appointed, but something that goes beyond that.
Well, we have no additional questions, so I will go ahead and open it up for testimony in support of Assembly Bill 344.
Good morning, Chair, members of the committee. My name is John McCormick, John, last name McCormick, McCormick, Assistant Court Administrator at the Supreme Court. The CIP program is one of the programs that's in my portfolio, so I've been involved with this issue for a few years now, and just wanted to put our support on the record. Particularly for me personally, getting master out of statute is very important for the reasons that have been stated, and so happy to support this. Thank you.
Good morning, Madam Chair and members of the committee. Priscilla Maloney on behalf of the alternate public defender's office in Washoe County. And just in case that name trips up some of the members of the committee, the alternate public defender's office was created several years ago because we had so much work in Washoe County. We needed specifically in 432B cases, if you think about it, we have always 2 parents. So we have a co-defendant per se on every case. So that is why we have the alternate public defender's office of Washoe County. We are in support of this bill today. I am standing in for my chief, Bill Hart, who is out of town and unavailable to be here by telephone. And I'm taking a quick look at this amendment this morning, and we are in support also of this amendment. And then if the committee has no further questions.
We do not, but it is good to see you this morning. I don't think I've seen you this session so far, so.
Thank you, Madam Chair. If I could just to clarify my bona fides for the record, most of our past relationship has been in another context in this, representing different clients in this legislative body. However, for the last 3 years, I have been working for the alternate public defenders. And before I came to Nevada from 1988 to 2006, I was a public defender in Oregon. So these are issues near and dear to my heart. Happy to be here. Thank you, and good to see you again.
Thank you so much. Anyone else here in Carson City wishing to testify in support? Is there anyone in Las Vegas? Not seeing anyone. Broadcasting, will you open the lines?
The public lines are open and working. There are no callers at this time.
Okay, thank you. Then I will open it up for opposition testimony. Is there anyone here in Carson City that would like to oppose? Anyone in Las Vegas? Broadcasting, will you open the lines?
Public lines are open and working. There are no callers at this time.
Thank you so much. I will open it up for testimony in neutral. Is there anyone that would like to testify in neutral? Not seeing anyone here in Carson. Is there anyone in Las Vegas? Also not seeing anyone. Broadcasting, will you open the lines?
Chair, the public line is open and working. There are no callers at this time.
Okay, thank you so much. And with that, the bill sponsor does not have any final remarks to make, so I will go ahead and close the hearing on Assembly Bill 344. Thank you so much. Our next bill today that we will hear is Assembly Bill 35. This bill revises provisions, well, I believe the bill has been amended, so I will let the Attorney General and his legal staff explain. And Attorney General, your hearing's open, so proceed when you're ready.
Thank you, Madam Chair, members of the committee. Good morning. My name is Aaron Ford, and I am your Attorney General, accompanied by one of my co-workers, Mike Morton, who will assist in the presentation in a very brief presentation, Madam Chair. We are here to present Assembly Bill 35 to you this morning. As drafted, AB 35 is a bill that seeks to protect children in the rapidly growing and changing world of artificial intelligence. The bill currently will prohibit the distribution, production, or possession of computer-generated images or images altered by AI that depict a child engaging in sexual conduct. These types of images are currently not covered by existing law prohibiting child pornography. However, earlier this week, Senate Majority Leader Canizaro presented Senate Bill 263, which likewise addresses this topic. Her bill has my complete support, and I was fortunate to be able to present her bill with her on Wednesday to express that support. That said, there is one particular component of AB 35 that was not addressed in Senate Bill 263, a very important nomenclature change that needed to be done in statute. In that regard, the current statutory scheme in NRS prohibiting sexual explicit materials of a minor refers to the crime as either child pornography or pornography and a minor. While all understand what that term means, or those terms mean, the language does not always accurately reflect the crime being committed or the harm done to the victims of these crimes. To better articulate the crime and its harms to both victims and the community writ large, AB 35 seeks to change references of child pornography in NRS to child sexual abuse material. It's called CSAM in the market, in the industry these days. This is not just a simple change in nomenclature. The word pornography connotes oftentimes constitutionally protected speech containing images or videos of sexual activity between consenting adults. A minor cannot consent to sexual activity, therefore, the current term in NRS do not properly underscore the criminal nature of these activities. Let me be clear, images and videos of the sexual abuse of children and crime scene photos in our statutes need to reflect that. Amending these statutory terms to child sexual abuse material is important to focus on the actual crime against the children, to recognize the trauma inflicted upon children by these images and the videos, and to underscore the absence of consent, control, and the choice for these child victims. This change in language is something that is happening across the nation. To this date, 7 other states, Arkansas, Maine, Montana, New Hampshire, New Mexico, Utah, and Vermont have adopted similar laws, and other states are considering adopting similar laws. And the United States Department of Justice has adopted this language change effective 2023. Chairwoman, I'd like to thank you for considering the bill. Committee, thank you so much for considering it as well, and our proposed amendment, and I'd be happy to answer any questions at this time.
And while I'm giving members a moment to type in any requests for questions they may have, again, I would like to thank you for your sensitivity and consideration in the importance of this name change. Because again, pornography is also with consenting adults, and children cannot consent, so thank you. With that, I will open it up with questions from Assemblywoman LaRue Hatch.
Thank you, Chair. Thank you so much for, I think, a very important change here. I noticed this bill has that change in many, many different places. And then I noticed on page 39, it includes direction to the Legislative Council to use this language in the rest of statute. And I just wondered, on a process question, does that mean just from now on when they're writing bills, this is the language they'll use? Or is that like interim work where they'll go and find other places maybe that it needs to be updated?
Michael Morton for the record. A little bit of both. So both the bill and the amendment as drafted do capture everywhere where the current terms are being used. And then sections 30 and 31, which are the ones that either direct LCB or direct, I think, the Department of Health and Human Services, whether they're drafting new laws, when they're codifying laws that are passed this session, or when they're drafting regulations. So just going forward, it'll be a one-time bill, and then won't have to address this issue again.
I don't see any additional questions at this. Oh. Assemblymember Cole?
Thank you very much. So my question is actually in section 1, sub 1, where it's a person shall not receive. And I just question, and then also the standard of knows or reasonably should know. One, let's say it's a video, and the conduct in question that's offensive happens at the end of the video. I won't know that this is bad until I've already watched it and received it. Do you see what I'm saying? So reasonably know or knows, I'm just wondering on the receipt end is where my question is.
Thank you, Assemblymember Cole. Do I go directly?
Please.
Thanks, Assemblymember Cole, for the question. I believe you were referencing the initial iteration of the bill. The amendment actually deletes sections 1 through 5, inclusive of the bill. So, thank you.
All right, with that, not seeing any more questions, I will open it up for testimony. Anyone wishing to testify in support of Assembly Bill 35 here in Carson City?
Good morning, Chair Miller, members of the committee. Jason Walker, Jason Walker, representing the Washoe County Sheriff's Office, as well as the Nevada District Attorneys Association, who are unable to attend. I will just note that prior to the amendment, I had significantly more than 2 minutes of support testimony in hopes to hit the timeout buzzer. But after the amendment, I will just say that I am in support of Assembly Bill 35. I was a stakeholder in the meeting with General Ford. What I'd like to note is that it's sad that everybody can understand the word child porn. I do understand that it should be changed to CSAM, although I did support Senate Majority Leader Canizaro's bill, Senate Bill 263. I'd also like to note a couple other Assembly bills were heard that can help us in this area, namely Assembly Bill 172 as well as Assembly Bill 275. Again, supporting AB 35. Thank you.
Good morning, Chair Miller. My name is Chris Reese, R-I-E-S, representing the Las Vegas Metropolitan Police Department. I'd like to echo my colleague from Washoe, thank the Attorney General Ford for this substantive bill, and we do support AB 35. Thanks.
Thank you. Is there anyone else here in Carson City in support of AB 35? Is there anyone in Las Vegas that would like to support AB 35? Not seeing anyone. Broadcasting, will you open the lines, please?
The public lines are open and working. There are no callers at this time.
Thank you. Then I will go ahead and open it up for opposition testimony. Anyone here in Las Vegas? Carson City? Carson City or Las Vegas? Not seeing anyone. Any broadcasting, will you please open the lines?
The public line is open and working. There are no callers at this time.
Thank you. Then I will open it up for testimony in neutral. Is there anyone that would like to testify in neutral? Here in Carson City, in Las Vegas. Broadcasting, will you open the lines?
There are no callers at this time.
Thank you so much. And again, our bill sponsor has no final comments. Thank you for that. So I will go ahead and close the hearing on Assembly Bill 35. I promised when I scheduled today, I wasn't trying to make it name change day or short, fast, or bill sponsor waive their final remarks day, but thank you so much. With that, we now have our final bill, Assembly Bill 387. So Assembly Bill 387 revises provisions governing guardianship of minors. And with that, I will let our presenters get settled in. I believe we have presenters down in Las Vegas as well. And whenever you are all settled and ready to begin, please proceed. Nice to see you in here, Assembly Member. We don't see you in here often, do we? Oh. That's nice. Committee Secretary, you can strike those comments from the, yeah.
So, good morning. First of all, thank you, Chair Miller, for having this meeting today. And just want to say good morning, Chair Miller, Vice Chair Marzola, and members of the Judiciary Committee. I love this committee. I've never had a chance to serve on it. However, for me, this is part of my home. Many of you know that my father did serve in the legislature in the 90s and early 2000s, and he was chair of this committee. And the decisions that he made as a member of the committee, as well as some of the issues that they faced, were some of the proudest moments of his life. And when he died, there were many individuals that came forward and said not only what the differences in some of the laws that he worked on, but also some of the laws that he didn't work on, that he just simply voted on in this committee, and how they changed other people's lives. And so just want to emphasize again how much I do love this committee and the work that you put in, because you put in some very difficult situations that make a difference for people that you'll never see. So thank you for that time of taking the time to read the bills and consider the information behind it. So back on track. My name is Natha Anderson. That took me a little bit of time to say. And it is my honor to represent Assembly District 30. I'm joined today by Jonathan Norman here in, oh, excuse me, I've got the wrong speech. Okay, sorry about that. I'm proud to present, sorry about that, as well as Marina Dahlia Hunt and, excuse me, Marcus Browers, who are joining us in Las Vegas. If you will please give me a moment. My notes got all messed up when I decided that it was more important for me to talk about my father. So, I am proud to present AB 387, which updates our minor guardianship statute to better serve the families, caregivers, and children who rely on this law for safety, certainty, and family security when faced with emergency, or when a parent is, for a variety of reasons, unable to safely care for their child. We all realize a child needs an adult looking after them. Current language in NRS 159A enables families and fictive cannot say that word, to navigate safely without children unnecessarily entering the foster care system. AB 387 updates the statute in a variety of ways. With the chair's permission, may I turn the presentation over to Mr. Norman? Thank you.
Chair Miller, Vice Chair Marzola, members of the committee, my name is Jonathan Norman, N-O-R-M-A-N. I'm with the Nevada Coalition of Legal Service Providers. Relevant to minor guardianship, it includes Legal Aid Center of Southern Nevada and Northern Nevada Legal Aid. Both programs represent children in minor guardianship. Legal Aid Center in particular is appointed in every new minor guardianship case in Clark County. Some quick history on minor guardianship. Prior to 2017, both minor and adult guardianship were contained in one statute. Obviously, the needs of minors who does not have an available parent and an adult who needs a guardianship are vastly different. Just the passage of time means most minors will exit guardianship by turning 18. In 2017, the minor guardianship statute we have today was split off into 159A, and the adult statute is NRS 159. This change came out of this body and was the culmination of years of work by the Guardianship Commission. The focus of those reforms were rightly centered on adult guardianship, because the crisis that led to prison sentences, national coverage, and eventually inspired a Netflix movie centered on the horrible abuse in Nevada's adult guardianship system. Minor guardianship was also improved in 2017. AB 387 builds on those reforms and will make NRS 159A better for the families and children who desperately need the safety and certainty that Assembly Member Anderson mentioned. We have worked with the Guardianship Commission to reach the bill before you and the conceptual amendment. The chairs of the Guardianship Commission, Judge Schreiner from the 2nd Judicial District and Judge Gentili from the 8th Judicial District,
as well as the membership of the Commission, have provided perspectives and ideas that have made this bill better at every turn. I am grateful for their input. We will continue to work with our partners on the Guardianship Commission and the private bar to ensure we hit the right policy in each section of the bill, so we aren't here in 2027 using the horrible phrase, "This is a cleanup bill." With that, I would invite my colleague, Mr. Browers, to cover some case examples, and then Ms. Dahlia Hunt to walk us through the bill and the conceptual amendment.
Hello, Chair Miller and committee. My name is Marcus Browers, Marcus Brouwers. I'm the team lead for Legal Aid's Minor Guardianship Unit. Our office is appointed to represent children in these minor guardianship cases. What AB 387 proposes is to clarify some murky language and make this area of law more practical to better serve the needs of families and help children. A few years ago, I had an 8-year-old client, Madeline. She had cerebral palsy and needed regular checkups. But still, she was the happiest little girl you could find. She had a little lisp, too. When her mother passed away, her mother filed for guardianship over her that February, and her grandma was trying her best. But because Madeline's grandma struggled navigating the court system, and because she was on a fixed income herself, she tried to serve by publication and certified mail, but was unsuccessful, and her petition was denied her first time around. Madeline's grandma had to pay for publication and certified mail again, and was successful. But she didn't end up getting granted guardianship until August, about 6 months later. That was a long time for Madeline to go without a guardian to get her to doctor's appointments. And if her grandma could serve in a more practical manner, she would be a lot healthier and happier. On another case, I was appointed to represent a 4-year-old cat for an existing guardianship where her mom never consented to that guardianship. Through hard work, Kat's mother recovered from her alcoholism. She had an apartment, maintained a job, and had consistent, safe overnight visitation. But it took her mom 4 attempts to terminate Kat's guardianship before the guardians finally relented and agreed to terminate. If the court had a child-focused standard of termination for guardianship, Kat's family could have been reunited sooner, which is what this kid wanted. On another case was for an 8-year-old Nicholas. When his guardianship was established in 2018, there was no clear duty for Nicholas's grandma to help maintain his relationship with his mom that was appropriate for his unique needs and best interest. So visitation was a struggle. Mom would get frustrated that their visitation was being limited after she proved she was stable. And it got to the point that both mom and the grandma started withholding Nicholas from each other, at least partly out of spite, which led to police involvement and hotly contested court hearings. When Nicholas's guardianship did terminate and he was returned to his mom's care full-time, Mom's relationship with the grandma soured so much that she wouldn't let Nicholas even see her, even though they had a close relationship. And Nicholas is the one who suffered the most here because he loved both his mom and his grandma, and he deserved to have both women in his life. Clarity from the court could have saved this. AB 387 is a good step in the right direction to help children, families, and parents through tough time. Please support this bill.
Good morning. Marina Dahlia Hunt, Marina Dalia-Hunt. For the record, thank you for the opportunity to speak today. I, like Marcus, am an attorney at Legal Aid Center of Southern Nevada, where I served as the team lead for the Minor Guardianship Advocacy Program until I was succeeded by Marcus. Over the past 5 years, Marcus and I have reviewed every single petition for guardianship filed in Clark County, and with our team have represented thousands of children in the system. Guardianship over a minor is a concept most people are at least vaguely aware of. Often, people envision minor guardianship being needed when a child loses both parents to a tragic accident. In reality, that fact pattern covers less than 5% of the cases we see. The vast majority of cases derive not from the death of a parent, but because of social factors like a parent struggling with untreated substance abuse issues or mental health, ongoing domestic violence or child abuse in the home, or a parent asking a friend or relative to take their child in because they're experiencing homelessness, incarceration, or deportation. Or, as we see often, a parent may simply have disappeared from a child's life. Back in 2017, when NRS 159A was created, the bill's presenter, Judge Walker, noted that 159A guardianship is sought largely due to circumstances that would cause kids to enter the foster care system. After 8 years of NRS 159A's existence and more than 5 years of legal advocacy in this area, we can tell you that assertion is absolutely correct, and that there are changes that need to be made to the current guardianship law to better match the needs of the children in the system. What this bill contains are a number of child-centric reforms that will fill gaps and better protect the health, welfare, and best interests of children. As Marcus noted in one of his case examples, most individuals seeking guardianship do so without an attorney, and the system is daunting. Sections 3, 9, 13, and 14 simplify the service requirements to better ensure that the children who need an adult to care for them don't have that need impeded due to arduous service requirements. When petitions are denied because of service, children can wait for 4+ months to even have a hearing on the petition. This means doctor's appointments can't be scheduled, IEPs might be delayed, and that's even if a child is able to be enrolled in school. And children sit in limbo in the meantime. Section 4 of this bill requires a petitioner to provide some additional information to the court in their petition, namely whether they have ever had their own child removed from their care by Child Protective Services, and whether they are able to meet the basic needs of the child by providing them with food and shelter. Because these cases are often resolved in one hearing, the court needs to have access to all of this information at the inception of a case to best make an informed decision. Otherwise, the next time a court may see the protected minor is 3 years later at a mandatory review hearing. A lot can happen in the life of a child in 3 years. Section 16 sets forth best interest factors for a court to apply when determining if a guardianship is appropriate. Without these factors, courts have little guidance and historically have relied on factors in custody law, which simply don't match the needs of children in guardianship. Sections 6, 7, 11, 15 center the child and, following national best practices, clarify the preference for the appointment of an attorney for a minor in guardianship. Also removes some of the confusing language in the current statute about the role of attorneys compared to those of guardians ad litem. Children are the most important people in these cases. Their lives and futures are affected the most of anyone involved. Yet, without an attorney, they have the least ability to advocate for themselves. Protecting their access to an attorney that only works for them also protects their best interests and protects their safety and security. In determining whether to grant a guardianship, this bill also requires both a minor over the age of 14 to consent to guardianship. I will say that is currently the practice, but not the law. And that the court must also consider the wishes of a child of any age as a factor in determining who is an appropriate guardian for the child. Children are experts in their own lives. Even feeling heard in a proceeding, even when that child does not get their desired outcome, is valuable for the child's well-being. Sections 13 and 14 of this bill clarify and expand the ability of the courts to grant temporary emergency guardianships under appropriate circumstances. As written, the law currently provides the ability to seek a temporary guardianship for medical reasons with supporting documentation from a doctor, and then for an undefined good cause shown. The issue with that is that for medical guardianships, someone who is not a parent or guardian has no ability to access the medical records that are required to get a temporary guardianship for medical purposes. And the undefined good cause standard has led to denials of very necessary temporary guardianships. Children need a safe caregiver. A child not having one is an emergency that can and does lead to their entry into the foster care system. Many parents want to remain involved in their child's life, even if they're unable to have them in their care. Section 18 recognizes that there's a constitutional presumption that it is in the child's best interest to be raised by a fit and suitable parent. Sections 17, 20, and 23 of this bill clarify that presumption and clarify that the guardian has a duty to assist the child in maintaining a relationship with their parent to the extent appropriate under the circumstances. Section 37 of this bill changes the standard that applies when a parent seeks to terminate a guardianship and removes a punitive standard that undermines parental rights. Sections 5, 19, and then 24 through 32 make changes on the estate side. The goals of these revisions are to simplify the law while protecting the estates of children. As John mentioned, we also have an amendment that we worked on with the Guardianship Commission that makes the following changes. So sections 3, 9, 13, and 14 defer to alternative service set forth in the Nevada Rules of Civil Procedure. Sections 6 and 7 set forth that the minor may also be appointed pro bono counsel or retain their own attorney, and then also specify that the rules of professional conduct for an attorney for a minor must adhere to the same rules as those adopted by our Nevada Supreme Court for the representation of children in abuse and neglect proceedings. Sections 13 and 14 set forth a procedure for the court to have a hearing and prior to the award or denial of a temporary guardianship at the court's discretion. Section 18 clarifies that a parent is presumed suitable to care for their child rather than stating a parent is presumed to be preferred for appointment of guardian over their child. There is no need for a parent to be appointed guardian over the person of their child. This amendment also clarifies that the court must consider suitability factors relating to the proposed guardian as well as the parent, and clarifies the procedure if a proposed protected minor over the age of 14 objects to a specific guardian or proposed guardian. Section 20 clarifies that a guardian has the duty to facilitate a relationship between a minor and their parent to the extent it is in the best interest of the minor, and as long as it complies with court orders for visitation. Section 24 clarifies that the court may consider or allowing an expense from a minor's estate in light of the minor's prior needs and routines. And Section 42 is amended to retain several provisions relating to specific estate issues. And with that, I will now turn it back over to Assemblymember Anderson. Thank you.
Thank you, Ms. Dahlia Hunt. I would just like to emphasize the situation of Madeline, Nicholas's, and Kat's are probably similar to many others that we don't know about. Their stories heighten the importance of having a constant, caring presence of someone in the child in their lives, because children know when you care about them, and they also know when it's a burden. Having that constant individual and having people recognize it, the judges recognize it, the children's advocates recognize it, the attorneys recognize it, but having the law be a little bit more, as stated by Ms. Dahlia Hunt, more child-centric is what this is being proposed today. So with that, thank you again, Chair Miller and the committee, for your time. We're ready for any questions.
Thank you so much, everyone, for your presentation. Our first question will be from Assemblymember Dahlia.
Thank you, Chair, and thank you for the presentation. I have a quick question about distilling one piece of this. So I know this is a big bill. Could you talk about how courts currently determine if a child is in need of temporary guardianship and how this law would improve that? Thank you.
Marina Dahlia Hunt for the record. So great question. The statute currently sets forth two standards for temporary guardianship. So the petitioner can either demonstrate through good cause shown that a child is having a medical emergency and cannot access the medical care that they need to whatever medical care they need. The issue with this, as I noted, is that when a petitioner does not have guardianship over the minor, they can't get medical records to prove that there is a need. So, for example, we saw this gap in a very dramatic way 2 years ago with a case that came in where two children had been basically dumped by their parent at a hospital because she was experiencing a mental health crisis. The grandparents tried everything they called CPS. CPS said that, the kids seem safe with you, so please just petition for guardianship. They petitioned for an emergency temporary guardianship because the oldest of the two children had a chronic, very severe kidney disease that was potentially fatal. There are very few experts on pediatric kidney diseases in Nevada, so they needed to go to a specific specialist, but to do that, they needed imaging. The imaging company would not allow imaging of the child's kidneys to be able to access that care. And so they weren't able to start the process of getting him assessed. He'd been living in a U-Haul van for a year, and he was visibly in kidney failure from the grandparents' experience. The petitioners were not able to get medical documents to be able to support their claim for temporary guardianship. And the court, applying the law, denied the guardianship without the appropriate information. We, on behalf of the children, ended up filing a petition for writ of mandamus with the Nevada Supreme Court asking for relief, and it was granted. In the interim, the children were brought into the foster care system because they were unable to otherwise access medical care. They remain in the foster care system today. And this bill, in part, the provisions relating to both medical guardianships, but also to the general kind of catch-all provision under 053, basically expand the understanding of a temporary guardianship to circumstances where a child is without a legal caregiver to provide them with those basic needs. All children need grown-ups to care for them. So that is the aim and the children we're hoping to capture by this change.
Thank you so much. I don't believe there are any additional questions at this time. So I will go ahead and, well, and for those who aren't sure what this triumphant moment is about, is that guardianship bills are quite intense and nuanced and detailed and often even controversial. But also this has been brought before last session, so many of the members are familiar with it, and the updates you made to it. So with that, I would say run from the table before they think of something, and I will open it up for testimony. Does everyone have early flights or something today? Because so I will begin here in Carson City. Anyone that would like to come forward and testify in support of Assembly Bill 387? Not seeing anyone in Carson, I see someone in Las Vegas. Please proceed.
Good morning, Chair Miller and members of the committee. My name is Leah Dodds, Leahdods, and I'm the Deputy Director of Foster Kinship, Nevada's statewide evidence-based kinship navigator program. And I'm here to express our support of AB 387. Last year, our advocates supported 256 families caring for over 400 children navigate the family court system by completing the correct forms and other basic procedural processes, as well as pay for service options like certified mail and publications, which are quite costly for our caregivers. Many of our caregivers are older grandmothers living on a fixed income and most often caring for many children. These families are usually doing this on their own and really just trying to get legal capacity to enroll kids in school, get them medical care, and make other vital decisions while their parents are unable to. We believe this bill will make it more accessible and effective. Some of the key improvements already noted are the alternative service, which will help relatives and parents know about the guardianship. Also, the clear guardianship criteria. So appointing guardians will also take into account the length of time has been out of parents' care and other safety risks. And we think most importantly, the clear visitation guidelines and pathways to reunification. This bill strengthens visitation guidelines by requiring courts to justify any restrictions on parental contact and establish clear conditions for terminating the guardianship and return to the parents. Research shows that consistent and meaningful visitation increases the likelihood of successful reunification. However, rates for children separated from their parents outside of the system is frustratingly low. So strengthening these guidelines is a critical step towards improving reunification outcomes and ensuring children maintain meaningful relationships with their parents when it's in their best interest. We think this bill is practical and common sense, and it will make it easier for caregivers to provide stable and secure homes for children. We also want to thank Legal Aid and more specifically the Guardianship Attorney Project for giving a voice to these unheard and unseen children. Thank you.
Thank you so much. Is there anyone else in Las Vegas that would like to testify? Not seeing anyone. Broadcasting, will you open the lines?
Public lines are open and working. There are no callers at this time.
Thank you. Then I will go ahead and open it up for opposition testimony, beginning here in Carson City. Not seeing any. Is there anyone in Las Vegas that would like to testify? Also not seeing any. Broadcasting, please open the lines.
The public lines are open and working. There are no callers at this time.
Thank you. Then I will open it up for testimony in neutral. Is there anyone here in neutral in Carson City? Not seeing anyone. Is there anyone there in Las Vegas? Broadcasting, will you please open the lines?
The public lines are open and working. There are no callers at this time.
Okay, then I will ask the bill sponsor, and again, we don't have any final words. We know when to call it a day. Yep. Thank you so much. I will go ahead and close the hearing on Assembly Bill 387. With that, our final item on the agenda for today is public comment. Is there anyone here in Carson City that would like to make public comment? Not seeing anyone. Is there anyone there leaving in Las Vegas? So I don't see anyone in Las Vegas. Broadcasting, will you open the lines?
Chair, the public lines are open and working. There are no callers at this time.
Thank you so much. I will close public comment. So I would just like to acknowledge that, one, this is the greatest committee in the universe, and everyone participating and presenting today, that we knocked out 3 BDR introductions and 3 very significant bills in 55 minutes. Right on. See you all Monday at 9. This meeting is adjourned.